The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have 5 cases that will be submitted this morning. Those cases are State of Iowa versus Vernon Huser. Second case is Daniel Klein and others versus Southgate Property Management. The third case is Joan Walton versus Martin Gaffey. Fourth case is Gary and Lori Porter versus Richard and Janice Harden. And the final case is In Re CFH, a minor child. Those last 3 cases are now submitted to the court, and we will hear the arguments in the Huser matter. Mr. Parrish.
Chief Justice Cady, and may it please the court, Ms. Hall, Vern Huser stands convicted of a crime he did not commit because the district court judge and majority opinion of the Court of Appeals erroneously analyzed 2 critical hearsay issues. The first erroneous analysis involved backdoor hearsay, allowing clearly inadmissible evidence into the trial that completed a triangle containing substantive evidence. This was the matrician testimony. The second erroneous analysis by both the district court and Court of Appeals prohibited Woolheater's statement against interest through Ms. Swank from being presented to the jury. Finally, both courts used an abuse of discretion standard as opposed to an error of law analysis, which would have entitled Mr. Huser to a presumption of prejudice regarding the hearsay, requiring the state to establish a lack of the evidence. Because Mr. Huser never received the benefit of the error of law analysis, it was impossible for him to receive a fair trial.
Mr. Parrish, would it be possible to conclude that the abuse of discretion might be the right standard to apply to the remedy that the court offered or made available, but the error of law standard is the one we apply to determining whether or not it's hearsay?
Well, Justice Mansfield, 2 problems with that. The first is that the hearsay objection was made earlier into the trial, so the hearsay at that point should have been reviewed by the court because the court determined it was hearsay. It was also preliminary determined in a motion in limine. So the error of law has to be given priority on the Parrish standard.
I'm sorry to interrupt you.
Sure.
But
anytime.
The court ruled it was hearsay, the statements.
Correct.
And basically, I think, correct me, I know you will, took the position that it was backdoor hearsay.
Absolutely.
All right, so, but then the question is, now what are we going to do? And the options would include, I suppose, in theory, an instruction, striking testimony, or mistrial, right?
Correct. That was the options that the district court had at that point. It could have reviewed it at that point, looking at the evidence in light of what had been received up to that point, right, which was not a lot of the inculpatory evidence that came in later.
But it seems to me, with respect to these 3 remedies, the question is, we should probably go through them one by one. One is you could have excluded the evidence Correct. In part or completely, and I know your position was at trial, I think, you ought to exclude her testimony in its entirety because you didn't want to focus on the erroneous testimony.
Because it had previously been excluded properly by the Court of Appeals and by the district court in all the preliminary rulings.
Okay, but the district court declined to strike it. What's the standard of review on that determination of declining to strike the testimony in its entirety?
So you're saying after the hearsay error of law is not reviewed, should then you have an abuse of discretion standard to come in to analyze those factors?
Yes.
That might be the case but then you have to look at the fact, how does the hearsay analysis have to be applied first? That then is applied toward the advantage of Mr. Huser, which was never done. The next question then is, well, do we go now to an abuse of discretion standard to review the fact that he did not apply the correct standard with regard to the hearsay. I'm not sure you get to that in this instance, but to answer your question, it might be an abuse of discretion standard at that point. But he still has not applied the proper standard to deal with the hearsay evidence.
The question I have with all this is that we've always said that if hearsay comes into evidence, prejudice is presumed.
Correct.
Now
Ross
whose
case says
burden
it.
or who has to show,
The state.
and how does that deal with these burdens of these abuse of discretion at law and things like that? How does that merge with that? Because
It doesn't merge. That's the problem, and that's what the Court of Appeals kind of left the tracks and why the dissent hits the nail on the head. Because she nails it right from the point that this was inadmissible evidence. It never been appealed pre-trial. It was properly applied, and that was going to be the way the case was going to proceed.
oh, your position is that if hearsay comes in and the prejudice can't be overcome by the state's burden, it's really looking at the whole record. I mean, they have to argue it and show it, but the question becomes, it doesn't matter what the standard is, you still have a reversible error?
You still have a reversible error, but this is the problem. If you look at it in the context of the whole trial and you apply the abuse of discretion standard, the error of law that was out there at the time this case first started is no longer applicable. So both the district court judge looked at it in terms of the whole record. The whole record wasn't out there when the error was made. You had to look at it in the context of when the judge should have ruled on the hearsay objection. But the next thing that is problematic about this case, if you look at Swank and the statement against interest that came in this case, the interesting aspect of that is that the court, after the objection by the state, allowed the backdoor hearsay to balance out why the Swank evidence should not come in. But that was inadmissible evidence that the court was balancing out against, and that was problematic. Swank and statements against interest was admissible evidence. It had been admitted in the
But
Wool
Mr.
Heater trial.
Parrish, as I read Rule 5.106, this sort of goose for the gander principle that,
And
good for the
firefighting
goose,
fire.
good for the gander principle that the trial judge applied, it does seem to allow for it. The rule says, when an act, declaration, conversation, writing, or recorded statement or part thereof is introduced by a party, then it goes on, any other part or any other act, declaration, conversation, writing, or recorded statement is admissible when necessary in the interest of fairness, a clear understanding, or an adequate explanation. So it doesn't require that what the trial judge said he was going to let in actually be otherwise admissible.
The problem, though, Justice Mansfield, is this. First of all, it's ruled inadmissible. We all understand that. That's how the case is going to start. The Court of Appeals said it was inadmissible. The lawyers knew in advance that if they were going to allow this evidence in, that they first had to approach the court. Now, I know we're dealing at a context now where we have Swank's testimony, and the court then uses this threat to say, if you're going to let this in, everything else is coming in. The problem with that, it's going to remain inadmissible. They could have taken a pretrial ruling to appeal it, but they did not. So it becomes inadmissible evidence. For all of the reasons, they never asked for those reasons for it to come in. So consequently, should they get the benefit of the bargain on that? Clearly not, because Mr. Huser then is deprived of a fair trial. If you say anytime the prosecutors engage in this kind of conduct, they can benefit from it. And that's the overall philosophical question this court is going to have to deal with. Are you going to allow this type of evidence that's clearly not admissible be admissible over the objections of the Court of Appeals and the district court judge and the motion in limine? That's the
Counsel,
question.
is this a case, a good vehicle to kind of give some teeth to orders in limine by if we require a third trial here, is that going to send a message to be careful about crossing the line?
Well, in 1997, in the Edgar case, you made it clear that that was the rule, that motions in limine, once you deal with a substantive issue pre-trial, you don't have to deal with it again. But a couple of things happened here, Justice Waterman. The first thing that happened here is that the the judge ruled in advance. They had the Court of Appeals ruling. They had the motion in limine hearing. And then the court allowed a different condition. It says, now, before you even think about bringing this in, you need to meet with me, tell the other lawyer, and advise. The difficult issue I think the dissent had with this case is that all of this was done, yet in the back pocket, the prosecutor had this case that he misread and introduced that. To answer your question specifically, is that where we have to go to get to this point, and that's the message we have to send? We need to reinforce the motion in limine. We need to give trial judges some better direction that you can't allow this. Once that motion in limine is violated, why make the defendants go through additional, even the state go through additional rules to protect themselves on a mistrial? So to answer your question, this is one philosophical message that the court perhaps needs to send. But in this case, the violation was so severe that I think the dissent sent it. Unfortunately, the majority opinion of the Court of Appeals didn't send it, but I think the comment that the dissent made that the district court judge was being generous when he says that they violated the spirit of it was, in fact, a very generous comment.
But isn't the trial judge better positioned than we are to sort of read the room and weigh all the evidence and decide whether a mistrial is the appropriate remedy?
Well, the problem is you can say that under the abuse of discretion standard, but what about the error of law, Justice Waterman? The error of law is what we have traditionally honored in the State versus Ross and other cases. When the Rojas case came out and there was this confusion about whether or not the hearsay trumps it and you go to the error of law, abuse of discretion, when you came out with the Ross case, you said, well, it's absolutely clear. This is what we do. And so the law is clear. Judges sometimes, and for whatever reasons we might be able to analyze it, once they see these errors occurring, as you notice in this case, they waited 2 days before they ruled, so 2 additional days of evidence is coming in. Psychologically, I don't know how that impacts the trial, but legally, I know as a trial lawyer, my client is entitled to a ruling on that hearsay motion at that time. When you shift it, and it becomes an abuse of discretion standard, you really get away from this whole idea of error of law, which is a lot more restrictive. The burdens change, as I believe Justice Mansfield or Justice Apple brought up at one point. Not only did the burden change, but the state, I believe it's Justice Wiggins, the state then has the burden of showing that it's not prejudicial because there's a presumption of prejudice. So if there's a presumption of prejudice, if you switch to an abuse of discretion standard, how is a defendant who's facing trial for his life is going to be able to protect him or herself? That's the problem that you're going to have in this instance.
How does the concept, abuse of discretion also includes errors at law? I mean, it's when it's in the laundry list. Abuse of discretion is when a court makes an error at law. So how does that play into the whole analysis?
Well, Justice Wiggins, it does, and we've thought about that a lot in preparing for this appeal. It plays in it this way. If you say abuse of discretion, we all know it's a much broader view and it doesn't work as favorable toward the defendant because you're looking at the entire trial. If you go back to the errors of law, perhaps some direction can be given. If an error of law comes up, you don't wait and continue the trial. You rule on that error of law in the context of what has taken place up to that point. Because at that point, the trial was going pretty favorable according to Mr. Huser.
All right, so let me just ask you. I mean, you read the transcript and the testimony came in and then you met with the court and you had the colloquy about Farrar, et cetera, et cetera.
Correct.
Supposing the judge would have said right then and there, I agree with you, this was hearsay.
And he should have.
Okay, I understand that's your position. And then what happens next?
He grants the mistrial because it's inadmissible evidence barred by the Court of Appeals, protected by the motion in limine, knowing that they had violated the motion in limine, knowing that the prosecutors had not come forward with the evidence in advance to let them know that it was going to be done, and being fully advised that this was a serious misreading of Farrar.
Could the court have said, well, it's hearsay, but we'll just strike the testimony? It's only 6 pages of testimony, or whatever it is.
It is. Angle that was forbidden in the first trial. And the evidence was a little bit different in the first trial than the second trial, regardless as to the Court of Appeals opinion, because no note ever came in left by Mr. Huser. Other evidence was not brought in that made the trial a lot more favorable
But you think it would have been error if the district court had immediately ruled hearsay and then simply excluded the testimony? That would have been error because the bell had been rung, if you will, I guess.
Correct. This is the problem. And I think as a trial lawyer, it's important to note this. Why do we fight so hard for motion in limine, both the state and the defendant? Why do they ask for it? Well, it could be because the evidence coming in is so explosive that you can't make an objection. Sometimes this court, in its evaluation, should put that in the context. The reason why this evidence was so explosive, because you don't want to make an objection in front of the jury, because it alerts them to the problem, so you want to fight it out in advance. I'm sure it's true in civil trials also, that the fight is not supposed to be on certain issues in front of the jury. So this is clearly inadmissible evidence that is explosive and could be
Why is it explosive? I mean, you look through the cases, and it's often testimony about drugs that's not related at all to the underlying criminal offense. The prosecution tries to get in that somebody's a drug dealer or some such thing.
Correct, in a murder trial, for instance.
And that there's cases that talk about how inflammatory that is and so forth. But the testimony here was simply related to who Woolheater was talking about, I guess. I mean, it's not like incendiary.
Incendiary in the sense and the context of the trial, it was because it was the only individual, as you could see from the review of the first trial transcript and the second trial transcript, that completed the triangle. I think the dissent got it perfect.
But not quite, maybe, and let me just
Okay.
probe. I understand your argument, but there was a Post-it note, as you know, that
Correct.
with Deb Huser's new resident address in Woolheater's possession.
That could possibly have been, but then there was no note from a bartender indicating that Morningstar, that evidence was not ever introduced. So when the Court of Appeals talks about you can review the entire record of both cases, the fact that there was an allegation that Mr. Huser left a note for a bartender saying, Mr. Morningstar, you're a dead man, was not in the record anymore at that point.
I guess I thought there was a Post-it note in Woolheater's possession that had Deb Huser's address, period.
There was a Post-it note.
That came in trial too, did it not?
It came in trial too, but the expert who testified did not testify to the positive identification. It was an issue of a middle ground, I think.
Of whose handwriting it was.
Correct.
Yeah, but doesn't, I mean, I think the prosecution's position, they'll speak for themselves, I'm sure, but the prosecution's position is, well, this is starting to tie, this triangle that you say didn't exist.
But Justice Apple is trying enough, though I think we've decided that that's not quite enough, not even to meet the standard of getting past a directed verdict. Plus, this gentleman, Woolheater, was a roof person who traveled around and was somewhat nefarious. But if you get back to the idea of swank, assuming that comes in, and you do the balancing test, and even go back to what Justice Mansfield said about it could have come in from all other reasons. The key to this is that swank could not get in, and he held it out based upon that reason. So if you have swank, and in the opening rebuttal statement of the state, they indicated there was no way that there was any other evidence pointing to anyone else. They had matrician, as you just pointed out. But we had swank, what would say she was with him when it happened. She took him to the scene. She traveled with him. The Court of Appeals says she was an accessory after the fact. That doesn't bear up with the facts of this case. She heard him say Ricky made a hell of a shot. She saw him make the phone calls beforehand. She was, and Woolheater made this statement to him that Morningstar had something against him. So if you talk about that note could have been used in argument to establish that maybe Morningstar collected that on his own for some other nefarious reason. So to indicate that the only reason that the note was there, that it's somehow connected, it could be a connection if you don't have swank. But if you go look at swank and follow swank in the first Woolheater case, they detail what Swank would have said. The state used her. If you go and look at Swank in the second case, they used her up until we got to the statement where they said Swank then cannot come in. But if you look at and the case that is kind of significant here, I believe Justice Apple, the Parrish case, and I believe Justice Katie, you wrote the dissent in that case, both factors that you all outline in the Parrish case are met by the corroborative factor, the trustworthiness, I think, Justice Katie, that you brought out in the Parrish case. All of those factors were met to let the evidence in with regard to Swank. Without Swank, you can't properly rebut the note that was outstanding with regard to the address of Deb Huser. You can't meet the matrician. You could say, well, matrician is okay. It was not explosive, Justice Apple. The problem is, if the opening rebuttal statement of the state is, there is no connection. When the state knew that Swank had been kept out and they had introduced Swank, they had given Swank immunity, they had used her statement as a trustworthy statement connecting Woolheater to the case, and what she did, she exculpated Vern Huser and inculpated Woolheater. If you go back to this cases of Chambers versus Mississippi, that leads to the whole idea of why we have statements against interest, and you follow straight through to the Paredes case, what they talk about in those cases is the fact that if you're facing a murder charge, you are more likely to, if you made a statement inculpating yourself, that's the most serious statement you can have in a statement of interest. So we were able to outline that that connection was made, and that was one of the reasons we asked that that be introduced.
Thank you, Counsel.
Thank you.
Ms. Hall.
May it please the court, counsel. The state first disagrees that the defendant has preserved error with respect to his hearsay challenge. Before trial, the court ruled that the specific hearsay statements addressed in the first appeal would be inadmissible under the law of the case. However, the court refused to grant the defendant's motion to suppress all of Woolheater's out-of-court statements, ruling it would address the issues as they came up during trial. And then, just before Deb Albizo took the stand, the court advised the defense that they should be ready to object to any questions they believed called for hearsay, and the matter would be taken up outside the jury. When these questions
Is there any representation that no hearsay would be introduced by the state? I've read the record, the colloquy. I mean, there was a conversation off the record that we don't know about, and then there was argument before the court, and professional statements were made about what occurred. And it seems to me the transcript indicates that the state said no hearsay would be introduced. Am I misreading the record?
Oh, the two points I just made are specifically in the record. I don't know if you're referring to the conversation among counsel where the prosecutor said we're going to talk about identity. That's what we're going to
right,
put
and then
Teresa on
right,
the stand.
and that no hearsay statements would be introduced through the witness. I mean, I'm asking a question about the record. That was, I mean, I thought that was part of the discussion.
I believe the discussion was more specific to the statements
Identity.
that were excluded
Okay.
on the first appeal.
Well, and the questioning went beyond identity, surely, right?
Yes, it did.
It introduced evidence that seems to be hearsay to me, and it's derivative hearsay, as the district court said. Obviously, it was based on comments that Woolheater made to the witness. So don't you have a problem?
But before we get back to the merits of that, of the backdoor hearsay claim, I want to again note that we believe that the defense should have objected at the prosecutor's first question, which mentioned Lance Morningstar, because he believed it violated the motion in limine ruling, even writing down on a note to co-counsel the word mistrial. But instead, they waited until all three questions were asked and answered, and then a follow-up question before they approached the bench and said...
Oh, but you have a motion in limine that doesn't in haec verba address what has occurred here, but it basically says that the hearsay of this witness is not admissible. So you've got the motion in limine already. You had a representation, I think, that they were just going to deal with the identity of the witness, issue, and that was not objected to. And you're right, of course, 3 questions were asked. And then there was the colloquy outside the presence, or the discussion outside the presence of the jury.
Where the
But-
defendant
yeah.
moved for a mistrial.
Right. But under all the facts and circumstances, we allow the timing of objections to be made in a fashion that doesn't necessarily unduly alert the jury to the nature of the prejudice and so forth. I mean, the dissent in the Court of Appeals obviously thought this was good enough under the circumstances. Isn't it true that ordinarily we don't require defense counsel to increase the nature of prejudice when there's another opportunity to present the objection, particularly when there's a motion in limine in place? I mean,
Well, we believe the questions that were asked were sufficiently different that they were not covered by the specific motion in limine ruling, and that when the defense counsel believes that's a violation of the motion in limine, he should object. And if you look at the lengthy trial record, he wasn't shy about objecting at any time, and he didn't have to jump up and yell mistrial or object. He could just quietly ask to approach the bench, as he did in this case.
Mr. Parrish suggests that in addition to the motion in limine, there was further discussion about how to handle hearsay problems, and that there was supposed to be notice given to the defense and so forth. A, is that accurate? And B, if so, what's your view of that?
That's why they had a partial hearing on it at the end of the day after Matrison testified, and then they continued hearing the next morning. And after hearing all of the defendant's arguments and the prosecutor's explanations, Judge Pilley, we believe, reasonably found that there was no intentional violation of a hearsay
That's not my
ruling.
question. I've read the motion in limine. And then Mr. Parrish, in his argument and in his brief, says that there was further discussion between the state, the court, and him, that if you start treading in the hearsay area or start treading close to potential problems, there should be notice given and an opportunity to kind of spade this stuff out. A, did that conversation occur? That's my first question. And why don't I leave it there?
Did it occur beforehand? Did the court
Yes.
advise them to
Yes.
come with? Yes, it did. And
Okay.
that is why the court, after the court first found there was no intentional violation of a hearsay ruling, the court did find that it was a violation of the spirit of the ruling because of the state's failure to bring in the questions to the court's attention in advance.
But where I'm headed at, doesn't that kind of, you're saying that the objection came 2 questions too late. But if the defense was operating under the assumption that if you tread close to hearsay, there's supposed to be some kind of notice and opportunity to discuss the matter to avoid a mistrial, doesn't that excuse an objection 2 questions late?
We don't think so.
Let me ask you, I don't really like the testimony. It kind of leaves a sour taste, but is it really hearsay? Because Matrician is not relating any out-of-court declarations. She's just saying that Will Heater mentioned 3 names, and there's no time frame given. There's just, did he speak, did he speak, did he speak? So isn't it really just the credibility of Matrician that is at issue here, and she's available for cross-examination?
Correct. The state would challenge that these were not backdoor hearsay. If you look at the definition of backdoor hearsay, which is primarily, that terminology is used in Texas criminal cases, it's questions that are designed to elicit the specific content of out-of-court statements. And there was no content of Will Heater's conversation to Matrison or his conversation with Huser that was admitted directly or indirectly. What was presented was evidence that there was a relationship between Will Heater and Morningstar, which we can know exists from other evidence.
Well, the
For
district
one,
court,
the fact that Woolheater killed Morningstar.
district court said that the statements in the second trial were obviously derived from the full statement that was declared to be hearsay from the Court of Appeals. I mean, admittedly, it's not, it doesn't have the same detail, and it's arguably not as florid, but nonetheless, the source of the testimony was an out-of-court statement. At least the district court seems to say that. It was obviously derived from the full statement. So doesn't, I mean, the source of this testimony is an out-of-court statement, is it not? Or is the district court wrong when it made its observation? Maybe it is.
I'm not sure the district court exactly found that. What got in was, did Woolheater ever speak of Lance Morningstar? Did he ever speak about Deb Huser?
Right, but it was right immediately after the,
And the answer was yes. I mean, again, no content came in, no motive evidence, which was what was the problem in the first trial.
Can you know, I think you've talked about it, that it maybe wasn't hearsay and it wasn't that bad, but let's assume it was preserved, let's assume it was hearsay to some extent. How do you overcome the presumption of prejudice?
Well, the state believes that the correct standard to apply is abuse of discretion on the court's mistrial ruling. That if the defendant had objected at the time the questions were asked, then it might be more of the straight errors of law, presumed prejudice standard.
An abuse of discretion can include an error of law. I mean, we've said that. It could be untenable, unreasonable, et cetera, or an error at law. So,
But the
I mean,
standard for a
and we've been-
mistrial is a little bit broader and, you know, can, under the facts of the case, the defendant still get a fair trial?
we've been pretty consistent that admissibility of hearsay wrongfully presumes prejudice. Now, is there anything in the record or that you can point to that negates that prejudice or overcomes the presumption?
I think the district court did a pretty good analysis of the potential for prejudice from this challenge testimony and denied a mistrial on that ground. And we think if you look at the totality of the case, the factual circumstances, that it was not prejudicial.
What are your best facts that get you over that?
Well, we know there was the fact that Woolheater killed Morningstar, so he had some relationship with him. We find an assessor's page printout of his property, as well as a note with Deb Huser's new address among
Sure, but-
Woolheater's belongings.
the real question, or at least the way the defense phrases it, is you need to link Woolheater and his client as together, that Huser aided and abetted Morningstar's murder. There's plenty of evidence that Morningstar, or not Morningstar, plenty of evidence that Woolheater committed the murder. And there's a lot of evidence, I think, that this divorce led to, and other activities led to ill will between Huser and Morningstar, no question about that. But like what the Court of Appeals said, the state's evidence of Huser's aiding and abetting was not overwhelming. The evidence linking Huser's motives with Woolheater's acts was incomplete without Woolheater's statements. So the focus on whether this is prejudicial, it seems to me, is whether the testimony that came in tended to do that, and not much else does. But please correct me, I know you will.
We don't think that the three questions and the yes answers brought in specific statements of what Woolheater might have talked with Huser about.
Not specific statements, no, but the implication was that in August or September, the conversation included discussions by Woolheater of
I mean,
Deb Huser and so forth.
The defendant was not shy about expressing his feelings to people in his office, to people he had business relationships with, to friends, to the best friend of his wife.
So, I mean, your argument might be that you don't need direct evidence, that we can infer. I mean, the record is florid on Woolheater's participation in the crime, and there's plenty of evidence of Huser's ill will toward his wife, and the jury can infer from that aiding and abetting. Is that,
Well, sufficiency is a separate claim, that we
I know,
also
but I'm
have
trying to
quite a bit
figure
of.
out, how essential this testimony was, and I think your position, I know you can
Ours
speak for
is
yourself,
not.
but you're saying it was really kind of marginal, the whole scheme of things. And you approach it from a larger perspective, I think. You're looking at the entire picture, and you're saying, well, there's plenty of evidence of Huser's at will, and plenty of evidence of Woolheiser. And the difference between you and the defense is focusing in on one particular element, aiding and abetting, and that the state has the burden of showing that Huser aided and abetted, and what is the at least direct evidence that Huser aided and abetted? And the answer is not much, according to Court of Appeals. And if so, that makes this testimony maybe a little more important.
I think you haven't mentioned all of the phone call evidence that's in the record. Woolheater was introduced to the defendant in July, and as of that time, their phone call exchanges started. And specifically on July 9th, there was a phone call between the two of them, and that was the date of the printout of the assessor's page for Morningstar's property that was found in Woolheater's house, along with the Ankeny Sanitation business card that said the words "call me." There's 5 calls to each other in August, but then in September, the defendant makes 24 calls to Woolheater. He initiated the calls. Now, at one point, he had hired him to do some gutter work for West Penny's rental building, and apparently that wasn't done properly, and he had to hire somebody else to finish it.
Counsel, could you address the defense argument that we should review the denial of the motion for mistrial on the state of the record at that time rather than the evidence that came in later? Was it proper for the district court to withhold ruling for a couple days? And now, if we're going to second-guess the denial of mistrial, do we look at the entire trial record or the record at the state of when the motion for mistrial was first made?
I think you could look at the entire record. The defense renewed its motions for mistrial, and so the court reconsidered those issues at least one more time, and then again in post-trial motions. And the court again gave basically the same reasoning each time for not finding that the trial was unfair to the defendant.
Should we give leeway to trial judges to decide when to make that call of whether to declare a mistrial? Are they in a better position to judge than we are?
Yes, I think they are in a better position.
And in deciding whether there was a fair trial, do you look at the whole trial or just an early piece of it?
I think you have to look at the whole trial. And I see my time's up, but of course, we also have an argument on the ruling that if the defense wanted to introduce Woolheater's statements to Zwank, then that allowed the state to revisit the issue of the statements excluded from the first trial. We think that if the defendant is seeking to change the landscape of the trial, that then the law of the case would no longer control, because the defendant would be trying to use exactly the same type of statements, Woolheater's hearsay statements about motive as a sword, but yet also try to keep the shield from the first trial ruling, and we think that is not appropriate. So the court's ruling on opening the door is correct. And we would also point to Iowa Rule of Evidence 5.806 that allows a party to impeach the statements of a non-testifying declarant with otherwise admissible hearsay, and we think those originally excluded statements would qualify as statements against interest and would be sufficiently corroborated. The state respectfully asks the court to affirm the defendant's conviction.
Thank you, Ms. Hall. Mr. Parrish, you may present your rebuttal.
In the rebuttal argument, the state makes this statement: Lance Morningstar had no connection to Louis Woolheater, didn't know him, nothing. Lynn Morningstar had no connection to Louis Woolheater. Where was the connection between Louis Woolheater and Lance Morningstar. That was Zwank. But also, it didn't give an exculpatory reason as to what statement Woolheater had made to Swank. And Swank indicated she did not know Woolheater. So what that puts us in the context is making Matrician's statement more important. To go back and look at Woolheater's statements and the state's argument with regard to that point.
Mr. Parrish, I mean, we've discussed this some, but
Right.
with regard to Matrician identifying these three individuals that Woolheater talked about or mentioned, you would agree with me that if it was hearsay, the normal remedy when hearsay comes in is striking the questions and answers, right? That would be the normal, everyday remedy,
Correct.
right?
If you can do that without bringing attention to the jury as to what just happened.
So in this case, what you wanted was something beyond the normal remedy, that is either striking of the entire testimony of the witness or a new trial, right? Or a
Well,
mistrial.
I wanted, first of all, that it was the court determined it was hearsay because it had been prevented in the other trial. The other question at that point is, I'm thinking, if you want to put me back in that time zone, obviously, if they knew the rules, as has been pointed out by this court that they should have known, that borders on prosecutorial misconduct. That's one of the terrorizing factors about this case, is that they did know the rules. They intentionally violated. Now, I realize the court ruled they did not, but what is the excuse they've offered for why they did what they did?
But the question I have is, don't we have to give the trial judge some leeway, some amount of discretion in deciding whether to go beyond the standard remedy and grant the higher level remedy that you wanted in this case?
We do have to give them some discretion to do that, but within the parameters of what the violation of the law is. If it's an error of law, then you have to first look at that. And the idea that this was all hearsay, the connection to the hearsay did not come in until the third question. Remember, this is being told outside of court is only for identification, which everyone concedes, no one disputes that. It was not until the third question, and I tried to time it, it takes about a second and a half to ask that question. That's the time that that question was asked that made the connection. Then you have the exculpatory evidence.
Explain that a little more. What do you mean by it wasn't until the third question?
The connection, and without telling me what Mr. Woolheater said, did he speak about Vern Huser? If you look at the first two questions, we're not disputing that that's cumulative. It was actually the third question that completed the triangle that both the dissent recognized and the court recognized in the first trial. But it was more apparent in the first trial than in the second trial.
A little puzzled. How could the first two questions not be hearsay, but then when the third question is asked, it became hearsay?
Well, I didn't want to go down the rabbit hole of the prejudice argument, but that's really the critical question that completes the triangle. And I think Judge Tabor outlines that the triangle ultimately comes to substantive evidence. The third question links the other two questions together. And then you don't have a counterbalance to that, such as when the prosecutor says there is no link, because you can't get Swank in to rebut that, because then the court blocks us with inadmissible evidence that should never come into the trial. We go over to Swank and said, let's bring this in, and corroboration is increasingly important if you, in fact, have exculpatory evidence. That's the standard in Parrish. If it's more exculpatory, what you got to do is look at that statement a little bit different, a statement against interest. That would have at least balanced out the Matrician statement. We never had that opportunity. So what you have at the end of the day is inadmissible evidence being admitted. Then you have admissible evidence, such as Swank, not being admitted.
Let me ask this. All right, so you made the objection and you made a motion for a mistrial and the court overruled it. Did you then move to strike the testimony?
We did, and there were several remedies that are in the record. That's what we tried to do. Strike all of her testimony, not let the court be aware of it, not let the jury be aware of it, admonish the state that they never should have done this in the first place. So we did present certain remedies.
But it was to strike the entire testimony and not just the 3 or 4 questions, if I...
Correct. That is correct. I'm sorry. Go ahead.
Why don't you address the phone business?
I will, and I had that in my rebuttal. The phone records...
But let me ask, just
sure.
say there's one additional feature of it, and that is that it seems like the phone, the volume of the phone calls after the murder precipitously declined. A, is that right? And B, what's your explanation?
At the same time, and we had evidence to show that there were other people who were doing work for Mr. Huser at that time. He found out he had a dispute with Mr. Woolheater about completing the work. There were no records of what the conversations were, no memorization of what was taking place at that time.
Okay, but the status of the record then is there's prior to the murder, the month prior to the murder, saying the murder is September 30th, the month prior to the murder, there's 24 phone calls between Woolheater, the trigger guy, and your client, and then afterwards, it just disappears.
And the testimony was presented that the work was completed at that time by another contractor who came in and did the work. There was no necessity for him to hire him anymore to complete the work. One statement in conclusion, did I get some more time or is my time up?
You may sum up your rebuttal.
To look at Swank, I looked at Swank and tried to decide what issue was there, whether he was given a catch-22, a Hobson choice, or a no-win situation. Seems like he was given a combination of all three. And that was Huser's choice. In essence, there is a higher philosophical question that this court has to address here. Was this okay, what the state did in this case? The Court of Appeals missed it when they didn't do the hearsay analysis on error of law, which perhaps they should have done, which we perhaps would not have been here at this time. The trial would have proceeded by now. But they did not answer that ultimate question. They did it as an abuse of discretion, which favors the state. So we're asking the court to reverse this case, send it back on two grounds I've mentioned in my opening. The first is that Swank's testimony should have been allowed, and inadmissible evidence should not have been used as a counterbalancing factor. And second of all, it was hearsay that was introduced in the trial. Thank you, Your Honors.
Thank you as well, Mr. Parrish. The case is now then submitted, and we'll next hear the arguments in Klein versus Southgate.